This program is brought to you by Emory University.
So our first panel, panel one, is going to be on gun-related crime and enforcement, state and national considerations. Our moderator, who is on the way now, his name is Professor Morgan Cloud. He is the Charles Howard Candler Professor of Law here at Emory University School of Law. He teaches and writes about criminal law, criminal procedure, constitutional history, constitutional theory, and comparative constitutional law. In addition to his Emory courses, Professor Cloud teaches and lectures at other universities. In the United States, he has been the Robert Daniels Distinguished Visiting Professor at the University of Iowa College of Law, a Distinguished Visiting Professor in Advocacy and Dispute Resolution at the University of Tennessee College of Law, and a Visiting Professor at the University of Mississippi School of Law. Professor Cloud lectures regularly to academic and professional groups in the United States and in other countries. Recent lectures have been delivered at the University of Heidelberg, the National Judicial College, and the National Center for Justice and the Rule of Law at the University of Mississippi. Please join me in welcoming Professor Morgan Cloud to the stage. Thanks.
I think Devin just wanted to embarrass me to make me walk up the stairs. Well, it's a pleasure to be here. We have a great panel. I'm going to focus on having them talk and not me talk. Because of the way the schedule's gone, we're going to have a period of time of about 40 minutes of discussion among this group, and then we'll have a timed and pretty long Q&A period for you folks. And it looks like the Q&A's got, for you guys, there are microphones set up there. Our panel, I'm just going to go through it in alphabetical order, all of them have career experience in prosecution and defense on cases involving our issues this morning. Matt Dodge, and I'm going to do this quickly because we got started so late, is an appellate attorney with federal defenders here in the Northern District of Georgia, and before that, I just learned was in the state system as well.
Yes, sir. Fulton County.
Paul Howard is a graduate of this law school. We're proud of that. He's been the district attorney of Fulton County, and I just made a joke about it, but since I'm older than everybody, I get to, since the previous millennium. He's in his sixth term as district attorney.
They don't get that.
I'm sorry.
That's all right. That's all right.
And we are just delighted to have him with us. David Patton is the federal defender in New York City for what, 4 boroughs? Is it 4 boroughs? 5?
Southern and Eastern New York.
Southern and Eastern districts, yeah. And has had a varied career where he's been a federal defender, he's been a law professor, he's taught at a variety of schools, I think including most geographically close, Alabama. You were at Alabama, right? And finally, Sally Yates, someone who, I have to tell you, it's hard, but she went to Georgia Law School. But we have one connection. While she was Deputy Attorney General of the United States, the second highest position in the Justice Department, Emory gave her our Epic Public Service Award about 3 years ago. So we claim you too.
And I claim Emory.
Yeah.
So, yeah.
What we're going to talk about, I have no doubt that somehow the Second Amendment will come up this morning, but our focus is going to be on a different set of issues, and that is the processes and policy decisions made at the local and federal levels, including interaction between the two levels of law enforcement in enforcing gun laws and trying to reduce gun violence. It's a funny, in a way, the way we're going to address it is kind of an unusual focus in the world of the Second Amendment and guns, because we're kind of all on the same side. I mean, the goal here is to reduce gun violence, and I don't think anybody is against that. But we find very significant policy decisions that impact people on the basis of race and economics and just geography that result from policies, in particular the enforcement of federal statutes. And this morning we're going to start by talking about two federal statutes. The first one has to do with, it was called the Felon in Possession of a Weapon statute. It's Section 922 of the United States Code, and we're going to start with David Patton, will tell us about the statute and how it works, and perhaps some of your experience and thoughts about this as well.
Sure. Well, it's not complicated. If you have a prior felony in your background, it's a violation of federal law to possess a firearm. That law's been on the books, as we heard in the first panel, since 1968, but it wasn't widely used by federal prosecutors until the 90s. Beginning in the early 90s, there began some formal programs between U.S. attorneys' offices and local police and law enforcement to start bringing gun possession cases into federal court. And it really kicked into high gear in the 2000s. And has pretty much stayed constantly at a pretty high level since then. So high level, what do I mean by that? When it ramped up in the 90s, by the end of the Clinton administration, you had 2,500, 3,000 of these prosecutions a year. By the mid-2000s, you were triple that, roughly. And it's stayed pretty constant since then. The way it works in practice varies from place to place. In New York, the way it works is these are almost entirely local police arrests that then get shipped to federal court for the purpose of imposing more severe sentences. So in New York, if you're arrested by the NYPD, they pull you over in your car and a gun is found in the glove compartment or trunk if they search the car. If they're searching your apartment and they find a gun in your apartment, or New York was famous also for stop and frisk, they find a gun on your person. You can be charged either in state court or federal court. If you're charged in state court, you're probably looking at somewhere on the neighborhood of 2 years in prison for possessing the gun. If they ship you to federal court, you're typically facing somewhere on the order of 2 to 3 times that amount of time, 4, 5, 6, 7 years, depending on your record. And if you have certain qualifying priors, then that triggers something called the Armed Career Criminal Act, the ACCA, which is the subject of some recent Supreme Court litigation, and that's a 15-year mandatory minimum. I've been a critic of these sentences and these penalties, both on the grounds that I think they've been pretty clearly shown to be racially disparate prosecutions. 75% of all felon in possession prosecutions nationwide are against Black or Hispanic defendants. That's an extraordinarily skewed number as compared to the population at large. I'm also a critic on the grounds of what Duke law professor Sarah Sunbeal about 15 years ago called the cruel lottery nature of these prosecutions. So the fact that the vast majority of criminal cases take place in state courts, including violent crimes, so assaults, rapes, murders, and so on. But just a handful of gun possession cases are taken out and prosecuted in federal court for far more severe penalties. And so that's my brief overview.
Sally, this statute's really interesting because the famous RICO statute incorporates state law to create federal.
I think you, Mike, yeah.
Well, I want to hear what she says. I don't care what I say. So the RICO statute, which incorporates state violations into a creating a federal crime was passed in 1970. This statute was enacted 2 years before that, and that's essentially what it does. It takes local crimes and federalizes them in a very direct way. As the U.S. Attorney here in the Northern District, what was your view of that as a matter of policy and practice? David's not the only person, for example, to criticize the way these statutes are enforced on basis of class and race. That's a fairly common complaint made by, among other people, Matt Dodge, even while you were U.S. Attorney here. What's the reason for this, and is there a legitimate justification, or is this, for example, just politics?
Well, I'm going to get to your question, and this is not a dodge of your question, but before I get into it, I have to tell you how thrilled I am to be here at the Randolph Thrower Symposium. When I was a young AUSA and was prosecuting one of my first big corruption cases, Mr. Thrower, whom I will always refer to him that way, was head of the City of Atlanta Ethics Commission. And so he was a witness in that case. And let me tell you, he was, and I missed this morning, so you all may have already talked about him, but he was the embodiment of everything that you want a public servant to be. And when he testified, he stood in stark contrast to the individuals who were on trial for corruption offenses. And so to me, for this to come full circle and to have an opportunity, and his daughter Patricia is a partner in my firm now, to be a part of his symposium is a real treat for me. So that being said, the issue here, this is of sort of how prosecutors on the federal side utilize all of the tools in the toolbox, but particularly this statute, the felon in possession statute. It's one that I think folks have really struggled with for years and years. And, different administrations have different approaches to this. When I was U.S. Attorney, the way that I looked at this is that we have a really limited amount of federal resources. The vast majority of all crime is handled by the guy who's sitting here to the right of me, is handled by the district attorneys across the state of Georgia. And the feds, much, much smaller percentage. So to me, the number one responsibility that we had then was to try to look at, okay, how are we going to use our limited federal resources to make our district as safe as possible? And reasonable people can have different views about how you ought to come out in that equation. I get that, and I recognize that. But from our standpoint, when we looked at gun charges here and issues of violence in the district, we tried to avoid, although I'm sure Matt will probably have some examples of times when we didn't, we tried to avoid what I would call the 3 guys in a car with a gun situation. What we tried to do was to focus our limited federal resources on people who were the most violent, who were the greatest threat to the safety of our district. That didn't mean that other folks who were violating the law by being felons in possession of a firearm shouldn't be held accountable. We believe that they should, but that those were more properly focused as state crimes. And so we did a variety of things. This may be a longer answer than you want. We did a variety of things to try to focus those limited resources. And one of the things we did, for example, was we put in what we call the Violent Repeater Offender Initiative. And in that, we set out really stringent criteria for cases that we would accept for gun cases in the Northern District of Georgia. And we looked not just at whether they had a prior record, but what that record was, how many convictions, whether they had any history of an active use of a firearm, how long it had taken from when they were convicted on one offense before they were committing another crime that would demonstrate that their propensity to recidivism, a whole variety of factors. We then, before we started utilizing those factors, we ran the algorithm, for lack of a better term, against some defendants that we had prosecuted that we knew were really bad, violent people, and then some others who weren't, to see how they would shake out in the algorithm, to see if it was identifying the right people. And we made some adjustments. And again, reasonable people can probably disagree about some of the decisions that we made, but those were the cases that we took. And federal agents, because there are some that come from a federal source, for example, DEA and ATF and others. But also locals would then bring cases to us and lay out to us the background and the reasons why this person was worthy of federal prosecution. And we turned down far more than we accepted, but those were the cases that we prosecuted. Now, across the country, different U.S. attorneys had different mechanisms that they used to try to determine how they were going to use their limited resources to make their communities as safe as possible. But the focus or the push during the Obama administration was to try to focus on more violent offenders. Now, there are going to be some exceptions. I know David probably has some exceptions to how Preet Bharara, who was the U.S. Attorney in SDNY, how he made those decisions. But that was our focus. I think the fact that that was our focus is evidenced by the fact that that's not the focus now in the Justice Department. Now there is a real push on pretty much anybody who's a convicted felon and who has a firearm should be prosecuted. And I don't have any notes up here, and that's probably reflected in my giving a long rambling answer, but if you look at the stats, and you all may have them, and see what the differences are from the end of the last administration to now to the number of gun cases that are being prosecuted, I think you'll see a difference in that approach. I personally don't happen to think that's the most effective, but that is the perspective of this Justice Department and how they believe they should go about fighting violent crime. And I promise the rest of my answers will be shorter.
I want you all to talk as long as you want. We want to listen to you. Paul, I'm going to get you in a minute. I'm going to respond first to
Mike.
I'm used to having that thing, taped to me, and that's what I need. The Federal Sentencing Commission's most recent report on sentencing, which is for fiscal year 2017, gives some of those statistics that confirm what David said and illustrate the details that Sally just brought. In fiscal year 2017, there were not 2,000 or 2,500, there were 8,064 firearms cases reported by federal prosecutors to the Sentencing Commission. So that's even more than the triple that you thought, that you surmised. The Sentencing Commission reports that more than half of the firearms cases brought by U.S. attorneys, 57%, involved the illegal possession of a firearm by a prohibited person, usually a convicted felon. That's the statute that we're talking about. So not only did the number of cases triple, a little more than triple, but more than half of them became these felon in possession prosecutions. In March of 2017, just a few weeks after the inauguration of the new president, there was a new initiative announced by Attorney General Sessions, which was to encourage, indeed almost to require, federal prosecutors in the 94 U.S. attorneys' offices to work with local prosecutors and local law enforcers to increase this number, to do just what happened. Fiscal year 2017 ended on September 30, so this increase in cases really happened in about a 6-month period between March 8th and September 30th. So there was this dramatic increase, and supposedly each U.S. Attorney's Office is required to work closely with the local prosecutors as is appropriate in the locality. So my first question to you, Paul, is what's been that effect? Has your relationship, your office with the Northern District, has it changed since this policy was enacted? I mean, are you having more cases? Do they ask you for more input? Do they ask you for referrals? I mean, what's been the process?
Well, first of all, I'd like to say good morning, and it is really a pleasure for me to be here. I really have to echo what Sally has said about Randolph Thrower and the person who worked with him, Felka Ward, who is also a graduate of Emory University. And when they were asked, I believe in 1974, to investigate a situation where the police chief had provided copies of an exam to officers taking a test, it was really strange that it was not prosecutors who investigated it, but the mayor actually had to ask citizens to investigate the incident, and it was Randolph Thrower who authored the report and who revealed to the public that they had in fact stolen the tests and it had been passed out to the officers. So Randolph Thrower is almost like an honorary prosecutor for what he was able to do. I also want to say this, and I don't want you guys to think that that I don't like Sally Yates because of some of the things that I might say, because
I'm stealing myself here. Yeah, okay.
I'm really proud of Sally Yates. In fact, I'm hoping after 2020 that she'll become the Attorney General. And I know that a lot of people in our country feel that we'll be a lot better off if Sally Yates. But let me just tell you, and it's not that I'm wiser than everybody else, but I have never enjoyed or liked or favored this process of the federal government prosecuting these crimes. I thought it was a bad idea. I didn't think it made any sense, and I have been against it. And for that reason, even right now, about the increase in the number of cases, as the local prosecutor, I wouldn't even know anything about it because there is somebody else missing from this panel. And guess who that person is? It's the police chief, because the federal government can actually go around the local prosecutor. It's not the cooperation, it is actually just getting the case. And so when I became district attorney, that was the thing that kind of alarmed me, that the U.S. attorney did not have to consult with the local DA to talk about getting these cases. They could simply get the cases from the police departments and they would be prosecuted by the U.S. Attorney's Office. So one of the things that I did, because now this is just a part of history, it had gotten to the point in Atlanta whereas the FBI actually stationed agents in the Atlanta Police Department. So they were able to identify a case and federalize the case before the local prosecutor ever had anything to do with it. One of the things I think it's important, and that Mr. Dodge, I don't know if you, that to understand about these cases, generally they did not involve a single offense. Usually the cases involved, it was an armed robbery, and then there was a weapons case. So what would happen is that you would see that an armed robbery case would be shifted to the federal courts because of the gun conviction. So what I tried to do as a local prosecutor is to figure out a way to get those cases back, because I thought it was the prosecutor's authority and jurisdiction to handle those cases. So the first thing that we did was to ask the, Ken Alexander was the U.S. attorney at that time, and we asked him to remove the FBI agents from the Atlanta Police Department, and Ken Alexander did that. So the next process that took place was the creation of what we call is a complaint room. And in that process, when the police made arrests, the cases were brought to the complaint room operated by the district attorney. We would then make a decision, and we tried to do it within 45 minutes as to whether or not the case should be charged. And so then we would immediately charge the cases. So what that would mean is when the U.S. attorney came over to federalize the case would already be indicted. So you can imagine what was happening in our jurisdiction. We would be sitting discussing a case that would go to the federal authorities. a case that had already been indicted by the Fulton County DA's office. And it was, it was not a lovely situation. So historically, I believe, as we sit here today, I believe I have, over the last 2 years, I think I've talked to the U.S. Attorney once. When he was first nominated, came by the office to say hello. And since that time, we don't have any communication. And so it would seem that the focus of the law should be some reduction in the crime rate. And there should be some discussion about, well, if we're going to take these cases, there should be some subsequent reduction in the crime rate. Now, I can just say from my point of view, I don't see that happening. Now, maybe it happens in other jurisdictions, but I have not experienced that here. And so I believe that as history unfolds, we will look back, and I think many of us will say that we made a reaction to a lot of crime that took place during the 70s and 80s because of cocaine. And I think what we might see is that a mistake might have taken place, that maybe there should have been some different things. And I think the first thing that maybe should have happened is not the focus on the defendants, but the focus should maybe have been leveled at gun suppliers rather than the people at the bottom end of the chain and who were African American males who just happened to be in possession of a gun or using a gun for some other crime.
I told you the Second Amendment would come up here. No, I thank you for bringing that up, and that will cycle back in. Based on your kind of towards the end comments, not the last ones, I want to ask Matt Dodge about a case he's familiar with. The district attorney just told us about this process by which the local prosecutor would indict someone for a crime, and then the question became, well, are the federal authorities going to leave that case in the state system where it originates with a state crime, or are they going to prosecute this as well under this federal felon in possession statute? There are two really important cases that were before the Supreme Court this term. One of them involves just that issue and the constitutional dimensions. A man named Gamble has challenged what's called the separate sovereigns doctrine, which means in this situation that Mr. Howard just described, of a person being arrested and prosecuted, indicted for a state crime, can then also be indicted by the U.S. attorney for the federal crime, this felon in possession statute. And there's a very, I think, very well argued and sophisticated debate within that case, which was argued about exactly 2 months ago, hasn't been decided yet, about whether that violates the Fifth Amendment prohibition against double jeopardy or not. So I was going to do something else, Matt, but I want to, since I know you know this case, I'm going to ask you to talk about it and explain the implications in light of what Mr. Howard just said.
In Gamble, the defendant was prosecuted in state court for possessing a gun, and he was convicted, and then later the federal government indicted him for the very same crime, the very same gun, the very same event. And he was prosecuted and sentenced for that federal case as well. And he thought that was unfair. Under the Fifth Amendment, we're told that a person should not be put in jeopardy twice for the same offense. And that kind of sounded like that's what happened to Mr. Gamble. And he filed a motion to dismiss. He lost, and the case is now in the Supreme Court. At the argument a couple of months ago, the justices were very interested in talking about federalism and asking lots of questions about the roles of the state government and the federal government. Should a person be regulated twice by both for the same event, the same act? So we don't know how it's going to turn out. It seems like it might go either way. But this is very close to home for us here in Atlanta. I worked in the Fulton County Public Defender's Office for 7 years during Mr. Howard's first 2 terms. And then I came over to the Federal Defender Program here in Atlanta, where I've been for 14 years, and I tried cases for all of Ms. Yates' time as U.S. Attorney. And I see a number of AUSAs in the crowd today who prosecute violent crime and prosecute gun crimes. And we see this all the time, where Mr. Howard's office will make an arrest, will prosecute someone for not only the gun, but maybe a crime that came along with it, a drug possession or a drug sale, a robbery, something along those lines. And Mr. Howard's office investigates the case, works with the APD, indicts the case, goes to court, and after some time, that person will be convicted. He's then sentenced by a state court judge who's going to impose some term of prison or probation, depending on that person's record and the facts of the case. And the case is over, and it seems that justice has been done, at least to everybody involved at that point. But all too often, the U.S. Attorney's Office will then surprise everyone with an indictment months later in federal court. And that person will be brought over from the Fulton County Jail or state prison, and he will be arraigned in federal court and told that he's charged with the very same gun and the very same event for which he's already serving a sentence. And for years, I litigated this. Many other lawyers have as well. We've litigated this in court, and we've gotten nowhere. The 11th Circuit and every circuit in the country has said that that's perfectly fine. And the reason they've done that is that the Supreme Court for decades has had this legal fiction called the dual sovereignty doctrine, which says that the state of Georgia and the U.S. government are entirely independent and separate sovereignties, and they can each mete out justice as they see fit. They can each enforce their own laws as they see fit, even if they overlap, even if they're both hammering away at the same nail with different hammers. So Gamble is still undecided. We'll see this term how the Supreme Court resolves the problem, but we very well may lose in Gamble as well. The oral argument suggested that the justices feel a great gravitational pull by stare decisis and may simply leave the rule as it is.
Thanks. David Patton, I want to ask you 2 things. The first one is just if you can comment about the practices in the Southern District and Eastern District of New York and how they compare with those that have been described about Atlanta. And then I would like you, because you've written about this, to start a discussion that maybe we should have just started with, and that's the issue of race. Both you and Matt Dodge in your work have raised real concerns and issues and used things like statistics to argue the disparate impact racially of the enforcement of these statutes. And so I'd like you just to compare what we do here in Atlanta to New York and then bring up the issue of race. Talk about that.
Sure. Fortunately, in New York, we don't see a lot of dual prosecutions for the same conduct. You know, we all swim in our own waters, and so I'm always surprised when I hear about different practices. There is something, or there used to be, I haven't had to look at it recently, something called the Pettit policy in the U.S. Attorney's Manual that suggests that federal prosecutors should be very cautious about doing that, and they have to meet certain hurdles before they do it. But so we haven't seen a lot of that in New York. We do see very disparate, formalized policies. I think one of the things that you have to keep in mind, particularly when we're talking about race, and I don't think you can ever have a discussion about gun policy in America without talking about race, because they're so intertwined in so many ways. But, you know, all prosecutors, state, local, federal, have a lot of discretion, an enormous amount of discretion. But at the state and local level, most of the time, prosecutors are responding to some report of a crime, or the police bring somebody in. So yes, there's discretion about what to do with them, but they're not really just sort of reaching out and sort of plucking people out as part of an overall strategy. federal prosecutors, and this isn't the only area where that happens, but to me it jumps out. I mean, this is discretion on steroids, right? The decision is not, will this person be prosecuted and punished? That's going to happen. They've been arrested by the NYPD. They're going to be prosecuted and punished. The question is, are we going to double, triple, quadruple, quintuple their sentence? Particularly when I look around in the Southern District of New York, there's a formalized process to bring these cases from the Bronx. And the demographics are overwhelmingly poor people of color. In Manhattan, the NYPD and for whatever reason, I guess the U.S. Attorney's Office is a little more solicitous of the district attorneys. The Manhattan District Attorney has been a little more hesitant to give up their cases, so they don't come from Manhattan. So that right there is sort of this formalized system of bringing these cases in for much harsher sentences that bakes in racial disparity. And there are many other ways that happens, but the statistics do bear it out just in terms of who's being prosecuted for these crimes. And of course, when you're going to use a prior felony as a proxy for a status offense, that's already baking in a lot of issues that we have with race and the criminal justice system.
The disparate impact of our criminal justice system by race is not restricted to the South. I come from Iowa, which is not the most, but it's, in terms of demographics, a very white state. And the prisons have a very large percentage, wildly disproportionate percentage of African-American prisoners. I mean, it happens in Iowa, it happens in New York, not just in the South. But both of the cases that are before the Supreme Court about Section 922, the felon in possession statute this term, are from the 11th Circuit. And since we're here, and neither one's from Georgia, but we're here in the part of the country where these issues have the worst history. And so I want to turn to our Georgia folks and just raise this issue again in a different way. I know when you were U.S. Attorney here, Sally, Matt filed a bunch of motions arguing disparate impact about race, and I don't want to pit you guys against each other, but I wonder if you two could talk about that.
Come on.
Oh yeah, well, I'm crocodile tears, I'm obviously provoking this. So, but I really am interested because Matt's claims were, in what I've read, have been very statistically based, but there was reason to doubt the statistics because he couldn't get them. No one would give him the full data. He only had partial data sets. And so I just wonder how the two of you view that and whether there really was or is a disparate impact in the Northern District.
Well, I don't think there's any doubt that there is a disparate impact, specifically with African Americans in our criminal justice system writ large. I don't think Paul would probably dispute that either. The question is what the source of that disparate impact is. And that was something that we were very mindful of the entire time that I was with the Justice Department, not just during the time that I was U.S. Attorney or DAG. As we talk about these issues today, I certainly am respectful of Paul's point about that he's the district attorney of Fulton County and he is responsible for the cases that are prosecuted there and the respect that the feds should show for that. But I'll also say this, that U.S. attorneys across the country and people at the Justice Department likewise have a responsibility. And that responsibility is also to do everything they can to make the communities as safe as possible. And while the vast majority of these cases are and should be prosecuted on the local level, there are times when there are individuals who are very violent and who are responsible for a disproportionate amount of the district's violent crime. I mean, the fact is that we know there's a really small group of people who are responsible for the vast majority of violent crime in our communities across the country. And so we can either do what some people call the fishing with nets, which is going out and prosecuting every single convicted felon with a firearm and send them all to prison for as long as you can, which has all sorts of horrible consequences and certainly exponentially increases the racial impact there. Or you can do what I think is the more appropriate and the more effective thing, and some have called as fishing with spears, in that you try to identify that relatively small number of people who are responsible for most of the violent crime. And while I certainly understand the tension between the state and the feds, the fact of the matter is that some of these cases are prosecuted on the federal side because members of law enforcement and members of the community will be frustrated that there are people who have been convicted 3, 4, 5 times and who still are back on the streets very quickly. Now, look, I am a big believer in proportional sentencing. I've been advocating for a long time that we need to reduce our drug sentences, that we need to be focused, for example, on the high-level cartel people and not local street folks. So I am not a big believer in mandatory minimums at all. I think all of those need to be adjusted. But I will also say this. There are a relatively small number of people who are very violent and who threaten the safety of our communities. And those are individuals, I think it is entirely appropriate for the feds to carry out their responsibility to keep their communities safe and to use the resources of the feds there. And again, I don't want to make it sort of a point-counterpoint. I was surprised, too, to hear Matt describe a number of cases or that it was routine for people to be prosecuted both in the district attorney's office and in the U.S. attorney's office. Because I can tell you, I was U.S. attorney for 6 years, and there was never a single instance of Stephanie, the head of the Federal Defender Program, or anybody coming to me and lodging a complaint about that. So I'm not saying it never happened. I want to believe that there were good reasons why it happened in the instances they did, but I wouldn't want you to leave here today with the impression that that was the routine, the regular way that it was happening.
Well, let me say this, and being African American, of course, people ask, well, how could you serve as district attorney when always the number of African Americans arrested, prosecuted, and convicted are disproportionate to the population? What I keep trying to remind people of is that we're actually, in my view, looking at the wrong part of the process when we began with the arrest. Because the real question is, what is it that keeps causing these same defendants to repeatedly show up in our criminal justice system? Because those are really the hard questions. In fact, the stuff that we're talking about now is really easy. The hard questions are questions that really relate to lack of opportunity, not having a job, not having a career, and not being able to take care of your family. So if you're prosecuting cases and it's in Newark, New Jersey, the disproportionate number of the defendants are going to be African American. And so if you focus upon that, I think you really miss the important element of it. So let me point out something else with the Project Trigger hook that I did not like, because let me tell you what I thought was the disparity, because you got to remember the disparity is not between African Americans and non-African Americans. It's between similarly situated African Americans. So this is what I would see happening. Someone who was arrested for theft by shoplifting, but that person was a convicted felon and then they also had a gun. That case would be transferred over to the U.S. Attorney's Office, and that defendant would end up spending 14 months or more in federal prison. Well, there might be in our county 300 other defendants with the same exact arrest and circumstances. And so the question becomes, well, how did they get this one guy? And he got 14 years in prison. And how about the others? Why didn't they receive the same sentence? I just thought it was like a lottery, a bad lottery, that you would end up being the unlucky person to get arrested. And I think that it's essentially unfair. So I don't think that maybe the focus ought to be the discussion of black versus some other race, because I think in this provision, you really got to look at what happens to people that are similarly situated. So in my situation, what would happen, and this is the reason I just don't want you to think I don't love Sally, but what the U.S. Attorney would do is to ask our office, after a case had been indicted, and it had been indicted for some time, they would ask, could we adopt the case? And so,
Please.
yeah. But so when I started as DA, normally what would happen is they would talk to some of the assistants. Well, you know, when you've got 300 or 400 cases on your calendar, it's easy to say, okay, fine, hey, you can take one. But I changed the policy. And I said, no, if you're going to do that, you have to write the DA a letter and ask for permission to do it. Because this is the question that I would ask is, why? What sense does it make? And this is the question that Matt talked about, is if the state has already indicted the case, the state laws in Georgia are pretty tough, so why are we handling the same case with the same defendant under the same facts? And on most of the occasions, I would say, no, we're not going to relinquish jurisdiction, and the case would go forward. So again, I really think that unless the questions resolve around some data, some goal of reducing specific crime, I believe that when we look at it in the future, we might conclude that maybe it was not the wisest way to use the federal resources. And that's just my opinion, Sally. Yeah.
The issue of selective prosecution, excuse me. You know, I'm too old to learn new things, like this new technology called the microphone. Who knew? This idea of selective prosecution, Matt, I know it's been a part of some of the work you've done. How do you respond to both what Sally and Paul said about the issue of selective prosecution?
Ms. Yates tells us that the goal of the U.S. Attorney's Office in prosecuting these gun cases is to get the most violent people in our district off the streets. That's a reasonable goal. I think everyone would agree with that. But that begs a couple of important questions. Is the use of the federal gun laws the most effective way to do that? Is it effective at all? You know, Mr. Howard's office specializes in crime prosecution, local street crime, gun violence. They do it well. They're more than capable of handling this on their own. And as Mr. Howard said, there are steep penalties in state court as well for gun violence. The other thought that I have is that the gun prosecutions in federal court, the people chosen for that cruel lottery, are both over-inclusive and under-inclusive. When the federal government indicts that population of gun cases, they aren't simply indicting the most violent people in our community. Many of the defendants that I've had, the clients that I've had over the years charged with these crimes, their criminal histories have led to these recidivist statutes because of a series of commercial burglaries committed late at night when no one's around, or selling crack cocaine on the street corner in broad daylight and being arrested and convicted for that crime several times. There is no real correlation between the worst violent offenders in our district and that population of people who happen to be brought into federal court for gun prosecutions. It simply hasn't been effective in reducing the gun violence and the crime rate in our district. It seems that there's a never-ending stream of federal gun cases, but not much is changing on the streets. So, in many ways, because it's so arbitrary who is brought to court, and because it's such a small percentage of people, as Mr. Howard said, who seem to be just given this unfortunate fate of a federal prosecution out of nowhere, then we have to ask a question about who is actually being chosen for this arbitrary prosecution. And if you look in the federal cases in our district, you will see that the defendants charged and convicted under the Armed Career Criminal Act, which is the most severe punishment for felon in possession, are overwhelmingly African American. It certainly matters to me that 93% of defendants sentenced under that statute in our district are African American, when only 30% of the population in the Northern District of Georgia is African American. I don't know what to make of that, but it certainly seems worth raising the question about why are we enforcing this extraordinarily punitive statute against just one group in our population when that statute is enforced so arbitrarily and rarely. I did litigate this for about 5 years, a number of years ago, and I lost motion after motion. And I began with this statistical analysis that I've just summarized for you, and it wasn't even a surprise, of course, to anyone. That's an open secret in our district, that virtually every defendant sentenced under this statute is African American. The response from the government was generally along the lines of what Ms. Yates just said. We go where the crime is, and if the crime happens to be in the Bluff or English Avenue or other certain neighborhoods in Atlanta, so be it. But the problem with that is all of the federal initiatives that have focused on gun prosecutions have focused on those African American poor neighborhoods in our district and virtually nowhere else. And at first, it's certainly reasonable to say we're not targeting African Americans. We're simply targeting violent crime and guns. But the problem is when year after year after year you see that the only faces that come into court are African American, and defense lawyers like me are filing motions year after year asking questions about it, even if that's not done with malice, eventually that knowledge is on your shoulders, and you've got to address that and at least ask some questions. And in my motions, I asked through the Freedom of Information Act, through Open Records Act requests, for information about how it is that the federal government has chosen in this lottery these defendants as opposed to all the others. There's violent crime all over the Northern District of Georgia. From Atlanta to Gainesville to Rome to Conyers, it's everywhere. There are guns flooded throughout our entire district. I don't think anyone's surprised to hear that guns are quite popular in North Georgia by all sorts of folks. So why is it that all this attention is being paid to this small group of people who are possessing guns at the end of this gun pipeline? And I don't know the answer to that, but in asking questions, I was stonewalled by the U.S. Attorney's Office in the DOJ. Mr. Howard's office responded to Open Records Act requests with documents, files. In every way, they opened up their office to answer my questions the best that they could. But the real source of information would be the U.S. Attorney's Office or the ATF, the federal agency that generally prosecutes gun crimes. And the government refused the FOIA requests. The district courts refused my discovery request. And the 11th Circuit stood by and said that that was all well and good. And I don't mean to be sounding overly bitter, but these questions are worth asking. They're worth asking, and there are an awful lot of reasons why the clients in these cases are African American, and many of them have nothing to do with the U.S. Attorney's Office. But it is a real rampant problem, not only in our district, but in David's district and all over the country. There must be a better way, a more effective way of keeping our streets safe.
Professor
Thank you.
Cloud?
I'm going to jump in, and this is not crocodile tears. I really hate to stop this at this point. I would love to have back and forth, but Devin is going to get a hook and pull me off here if we don't go to the audience. So we have about 20 minutes for questions and answers. There are microphones set up, but before we do that, I hope you are all as impressed as I was with our panel, and let's thank them. Again, I apologize to everybody for not having responses, but let's let some questions happen. My guess is that the responses will come out of the questions, perhaps. Yes, yes, sir.
Thank you all for that very enlightening panel. My question has an assumption built into it, and so if it's wrong, please correct me. But I'm left wondering if possessing a firearm in a school zone does not have a substantial impact on interstate commerce. How is it that a felon possessing a firearm in his apartment or on a stoop has a substantial impact on interstate commerce to support the underlying basis for the legislation that you're discussing? Thank you.
The question is based upon a 1995 Supreme Court decision called Lopez, which was the first time in 30 years a statute was declared unconstitutional because the Congress had not established under the Commerce Clause sufficient basis for the statute to be constitutional. After that, I think just the next year, 96, there was amendment to 922 to put in language about interstate commerce, and that's been upheld. So for all of you, what do you think about this, about the constitutionality of it?
The short and real answer is because courts have said so. Why they've said so, we could have, do I have a great deal of hope that that's going to change anytime soon? No. For where I am in New York, the courts rely on the fact that guns aren't made in New York, and so they have traveled in interstate commerce. So if you're possessing a gun, that gun has necessarily traveled in interstate commerce, and that's always a 3-minute part of all of our trials is, the ATF expert saying this gun traveled in interstate commerce.
But that commerce is common enough that there's a name, the Iron Pipeline, for guns coming from the South up to New York in particular. So, I mean, that interstate commerce fact, I mean, I don't think is disputed. I would assume they have to show this gun came in interstate commerce. But the rest of you, what do you think about this idea about the constitutionality, setting aside the reasonableness of having this federal statute based upon the Commerce Clause? Or is that just not even worth talking about because it's so well settled?
Well, I really believe that there are some greater questions that are raised by this relationship between federal and state laws. And one of them involves what Matt was talking about, requesting information from the Justice Department. Because right now in our county, we had a young man who was shot 59 times by the U.S. Marshals, and it took place in August of 2016. We received a report in our office from the Georgia Bureau of Investigation in February of 2017, and since that time, we have been trying to get the Justice Department to provide documents related to any investigation of the matter. We have not been able to get them to give the DA's office a single document. They even went further. They have even blocked us from interviewing the 16 officers that were involved in the incident. And so I have ended up doing the same thing as Mr. Dodge. I ended up having to file a lawsuit against our own government to get information about this case. And so in our investigation of the matter, we were surprised to find out that within the last 6 years that the U.S. Marshals had been involved in more than 100 incidents like this, and none of the officers involved were ever held accountable for it. So the question even goes further, because not only were they not held criminally responsible, the family members were not able to receive any civil judgments because of the claim of federal sovereignty or federal immunity. So I believe it's a question that goes even further. It's difficult to see how something that is clearly a local matter is converted into a federal matter. And I guess it's just, like you said, it's just because the courts say so. But I think it's something that we really need to examine, particularly when it has the effect of cutting off the local prosecution and also cutting off families who might rightfully deserve some kind of civil compensation for what is going on. So I just think these questions of federalism, there's some practical effects that I think that maybe we should look at. That's why I'm really pushing Sally Yates to become Attorney General. And the reason why is because I know that she is honorable, and I think that, and she has a lot of common sense, and I'm hoping that that will translate into better laws and better treatment of some of the defendants and some of the families.
Anybody? We have some, yeah, ma'am.
Good morning.
Sally, I'm sorry.
Mr. Howard, I thought it was really significant that you made mention of putting focus on the suppliers of weapons. And I wanted to know what is the strategy, both questions can kind of go for yourself as well as Ms. Yates, both on the state level and the federal level. What is the government doing to tactfully go after the suppliers, the weapon suppliers?
You aware of any?
Sure. I mean, I think on the federal side, certainly one of the ways that, again, we tried to use our resources was not just felon in possession cases, but gun trafficking cases. And Professor Cloud mentioned the iron pipeline from Georgia to the Northeast, because frankly, our gun laws here are so lax compared to a lot of other states that Georgia was at one point the #1 prime source state. It's sometimes then vacillated between second, third, fourth, but way up there in terms of a source state for guns that are then used in crimes in other states. And so one of the best ways that we can try to prevent those crimes is to go after those suppliers. Here's where one of the difficulties we encountered is that sometimes these guns are purchased by straw purchasers, and they go into an FFL, a federal firearms dealer, and they will purchase there. And there's no limit on the number of guns in Georgia you can buy at one time. But oftentimes they would also go to gun shows and to other places like that where they don't do background checks. And in fact, we had one undercover, where we actually captured on the wire where the traffickers were talking about going to the gun shows to fill their gun orders that were then going to be taken to the Northeast. You know, I'm a big believer in universal background checks. In the Obama administration, the president took the steps that he could through executive action to try to tighten the gun show loophole, but you couldn't completely eliminate it. I am a huge believer in that, because these are really challenging cases. Even when you can identify the straw purchaser, oftentimes the case dissipates after that, because being able to find where the guns go after that becomes impossible until then you unfortunately recover it in a crime scene in New Jersey or New York or someplace along those lines. And Paul, you may want to talk about what you all did with suppliers.
Well, I have to say, I am not aware of any comprehensive program to get at the gun suppliers. I know that I've had several conversations with the Manhattan DA, Cy Vance, because a number of guns from the state of Georgia ended up in New York, where crimes were committed, many of them against police officers. And but when we looked at the guns that were used in those incidents, many of the guns were purchased in our states legally rather than illegally. What I have observed during my years as the DA in Fulton County, that many of the prosecutions regarding guns being supplied actually end up prosecuting college students who are used as straw buyers. And the reason they use these students is because they don't have any records and they could purchase 3 guns. But it has not been my experience that there are prosecutions of people beyond those straw buyers who, as I've said, in many cases are just young people trying to make some quick money. So I have to say that maybe there's something going on I'm not aware of, but in terms of here in our state, I am not aware of a comprehensive program to somehow root out and hold responsible those gun suppliers.
I just wanted to add one thing on this. There's a real anomaly, to my mind anyway, in the federal sentencing guidelines.
Is that
that you actually face far less severe penalties for illegally selling guns than for unlawfully possessing guns. So, we're often kind of rolling our eyes in our office when we have clients who are accused of illegally selling a dozen guns and they're facing about a year, whereas our guy who's caught with, and this is not exaggerating, we have cases like this, 3 bullets in the nightstand that are just left over. They've been there forever in a messy apartment that gets searched for some other reason, and they're charged and looking at 5, 6, 7 years under a felon in possession statute. I mean, there's some real anomalies in the sentencing guidelines that we refer to the selling provisions as the NRA provision of the guidelines.
Well, we have time for one more question. Ma'am, go ahead.
I have 2 questions for Mr. Dodge. I think he may know who I am, since I've read lots of his wonderful briefs. He's a credit to our community.
Ma'am, would you please identify yourself?
I knew Mr. Paul would say that. I'm Frank Hull, and I'm on the 11th Circuit, so I thought I should stand up and ask 2 questions of Mr. Dodge, since he's used to answering my questions.
It's very familiar, Judge Hull.
Okay. And I don't think Sally Yates needs me to defend her, but
I'll take it.
But, and I am really alarmed by this concurrent conviction and prosecution on gun cases, because I never knew that was going on in our jurisdiction. I know about the Supreme Court case in Gamble. Ms. Yates says she doesn't knowingly have ever done that. Well, you have 2 convictions. I'm not saying the feds don't take cases before there's a conviction from the state. Mr. Patton says he doesn't know of that dual sovereignty conviction, dual sentences in New York. Do we have that problem in the circuit where we're having dual convictions and sentences on the same one drug possession? Have you had cases that happen?
Yes, Your Honor.
Okay, out of hundreds. Out of hundreds of cases, how many times? Because I was not aware that happened in our jurisdiction.
Well, I don't have any knowledge beyond my own practice, but I've had at least a dozen over the last 14 years that I've been in the federal defender program.
Okay, a dozen out of 1,000. I'm not saying it's right. I'm just trying to get a dimension of the problem so the audience understands it.
Sure. So I don't know the total numbers, the scope beyond me, but I'm just one of 20 attorneys in my office. And
I know, but how many cases have you had over the last 14 years? We've had a dozen.
I've had a couple of hundred cases of all variety. As far as felon in possession cases, I've had far fewer than that. I've had dozens.
I'm not trying to advocate it one way or the other. I'm just trying to get a sense of the dimension of the dual conviction.
I'm going to, just because of time, and again, I'm worried about Devin with his hook.
Okay.
If there's a specific question, would you please ask it?
Okay.
Only,
All
I'd
right.
say respectfully, just because we have about a minute or 2 left.
The next question is also for Mr. Dodge. And I'm just curious, because what I see in court on federal gun cases is at least half of them have a federal carjacking crime, 3 or 4 carjackings, 3 or 4 Hobbs Act robberies, 3 or 4 armed bank robberies, which is purely federal. And we talk about 8,000 gun possession crimes. It seems to me at least half of them are federal crimes, companion crimes, but I may be wrong about that too.
No, that's a fair estimate, Judge Hull.
Okay.
Sure. There are quite a few standalone felon in possession indictments, but you're right, there are plenty where the indictment includes all sorts of other violent crime as well.
And that's what I saw out of the Northern District of Georgia from
Yes.
Sally's office. There's always some big-time federal crime with it. Thank you very much.
Thank you. Thank you. Before we break, I just wanted to say, I don't often get to say this in front of a crowd like this, but listening to these 2 career prosecutors and 2 career defense lawyers, I must say it makes me not just pleased, but proud to be a lawyer. So thank you all very much.